So you get in an auto accident and you want to handle it on your own. You go through the process and the insurance company makes you an offer that you're not happy with. So you decide to file a lawsuit. Do you file suit against the insurance company or do you name the driver who hit you? Watch this video to find out. Hi, my name is Barry. Welcome to the LawFull channel. On this channel, I try to address common everyday legal questions and do so in a way that avoids the legalese or legal talk. If you're interested in the law or you have a question, please subscribe to our channel or reach out to me. If I can't help you, I'll find someone who can. No surprise, auto insurance companies can be very difficult to deal with. Their goal is to make as much money as they can through taking in premiums. And of course, to maximize their profits, they have to pay out as little as they can in claims. So it should come as no surprise when you start to deal with the insurance company that they nickel and dime you. They are trying to save money any way they can. They have made a calculated judgment that the vast majority of people will not file lawsuits against them. Most people aren't going to file suit over a few $100s, and definitely attorneys are not going to be able to file a lawsuit and incur the expenses over a modest amount. This often leads to serious frustration for people when they deal with insurance companies. I get calls all the time from people who are exasperated from their time spent negotiating with Geico or Progressive or Allstate. They all say the same thing: I want to sue the insurance company. Well, unfortunately, generally speaking, you don't sue the insurance company directly. You sue the driver of the vehicle that injured you. So let's take an example. Let's say you're involved in an auto accident and you get hit, rear-ended by John Smith. John is represented by Geico Insurance. You file a claim and you go through the whole process. You provide them your medical bills, your lost wages verification, and everything that they need to process your claim. In the end, they offer you only $10,000 and you don't think it's enough. You go to court and you file a lawsuit, but you don't name Geico Insurance as the defendant. It will be your name against John Smith. Now, when John gets served with the lawsuit, he's going to reach out to Geico Insurance. And Geico, as his insurer, has an obligation to defend him against your lawsuit. So they will hire or retain a law firm to represent him. So, when do you sue an insurance company? Well, insurance companies get sued all the time. But in the personal injury realm, you really only hear it come up in one or two situations. The primary situation is when you allege that the insurance company engaged in what's called bad faith. So, bad faith claims don't come up very often in motor vehicle accident cases. But when do they come up? It usually takes place when your attorney makes a demand of the defendant's insurance company that is far in excess of the defendant's insurance policy. In car accident cases, bad faith usually arises in this type of situation. Your attorney files a claim on your behalf with the defendant's insurance company. The defendant has $100,000 in insurance, let's say, and your attorney thinks that your case is worth significantly more than that. Despite this, the insurance company refuses to tender or offer you the full value of their client's insurance policy. So generally speaking, if that happens, and your attorney files suit, and you do recover significantly more than the defendant's insurance policy, your attorney might file a lawsuit against the insurance company itself and allege bad faith. If that's the case and you prevail, the insurance company could be on the hook for the whole amount, including attorney's fees and other costs and expenses. Practically speaking, though, you don't see this very often. The few times that I have used an allegation of bad faith, I didn't call it bad faith, and I've only really used it to try and encourage an insurance company to finally make an offer to our demand, or alternatively, to let them know that we're serious about pursuing litigation. Practically speaking, it's just not used that often. I have used it only a few times in the past several years, and I usually use it when an insurance company is delaying in their response to my demand package. I will send a letter to the insurance company subtly suggesting that they are acting inappropriately and that they should take steps to protect their insured's interests. Okay, it's time for your take on the law. Have you been involved in an accident and weren't sure who to sue, the insurance company or the driver who hit you? Tell me about it in the comments below. Or have you been so angry at an insurance company that you wanted to sue them directly? Let me know about that as well. Hey, thanks for checking out this video. If you like what you saw, please consider subscribing to our channel. And if you have any questions or comments, you can put them in the comments section below or feel free to email me. If I can't help you, I'll find someone who can.